Judgment in the matter of Sian Participation against Halimeda International Limited.
This decision of the Judicial Committee of the Privy Council is being handed down rather than just promulgated in the usual way for two reasons. First, because it resolves a difficult and important issue on the boundary between two public policy objectives, which has troubled common law jurisdictions around the world and led to conflicting outcomes. Secondly, because we have decided that the leading decision of the English Court of Appeal, from which this controversy has ensued, was wrong, and the Board is, for the first time, exercising a power given to it by the Supreme Court of the United Kingdom to resolve that question in a way that will be binding not only on the courts of the British Virgin Islands, from where this appeal originated, but also upon the English courts as well. The important boundary issue lies between two public policies. The first is that companies which cannot pay their debts should, by a simple legal process, be put into liquidation, or now administration, so that their remaining assets can be divided fairly, usually equally, between their creditors. That is done by an application to appoint liquidators in the British Virgin Islands and by a winding up or administration petition in England and Wales. Their effect is substantially the same. I will call both of them a liquidation application. The second public policy is that persons, including companies, which agree to resolve their disputes by arbitration rather than in court, should be held to that bargain. Usually, there is no difficult boundary there at all. Companies which dispute the relevant debt are not to be put into liquidation on account of it. If there is no dispute as to the debt, then there is nothing to resolve by arbitration. But unfortunately, not everyone agrees what is meant by a disputed debt. Is it enough that the debtor just says, without any explanation or evidence, "I don't admit the debt"? Or must the debt be genuinely disputed on substantial grounds? Traditionally, the companies courts of most of the common law world applied the latter test. A company could not resist being put into liquidation on the basis of an unpaid debt unless the debt was genuinely disputed on substantial grounds. But in the more recent international law of arbitration, again implemented in most common law countries, it is enough to trigger the obligation to arbitrate if the debtor merely denies or even does not admit the debt. If that is the case, the creditor may not bring an action or claim in court to enforce the debt, even for summary judgment. He must get an arbitration award first. An action or claim in court to enforce the debt will be stayed in the meantime. Sooner or later, these different perceptions about what amounted to a disputed debt were bound to come into conflict. A company faced with a liquidation application based on a debt arising from a contract with an arbitration clause in it would say that the liquidation was a prohibited way of enforcing a debt, which, because the company did not admit it, should first be enforced by arbitration. The creditor would say that the company was not genuinely disputing the debt on substantial grounds. This is exactly what happened in the present case, with the added factor that it has now been finally decided by a court, and is no longer challenged by the debtor company, that there is no genuine or substantial dispute about the debt on which the liquidation application is based. In the present case, the application to have the appellant Sian Participation Corporation put into liquidation was made by Halimeda International Limited, the respondent, in September 2020, and the issue whether the application should be stayed pending arbitration was heard in April and May 2021 in the High Court Commercial Division of the British Virgin Islands. The judge appointed liquidators over Sian and rejected Sian's application for a stay. Sian's appeal was dismissed by the Court of Appeal in November 2022. Sian has appealed to this court. This was by no means the first time a conflict about what amounted to a disputed debt arose in a common law court. It first arose in an appeal court in 2014 in an English case generally known as Salford Estates. By then, the legislatures of England and the British Virgin Islands had in their respective arbitration acts laid down a requirement for a mandatory stay of actions or claims concerning matters which the parties had agreed to resolve by arbitration. In so doing, England and the British Virgin Islands had followed and implemented provisions to the same effect in the UNCITRAL Model Law on International Commercial Arbitration and in the New York Convention of 1958. A disputed debt would certainly be a matter the resolution of which falls within a standard form arbitration agreement. In Salford Estates, the English Court of Appeal held, and everyone now agrees, that a liquidation application on the basis of an unpaid debt is not an action or claim to enforce the debt, so the statutory provision for a mandatory stay of the proceedings does not apply. But the Court of Appeal went on to endorse the lower court's decision to stay the liquidation application as a matter of discretion, mainly on the basis that to do so would uphold a wider policy in favour of arbitration over court proceedings than was reflected in the boundaries of the statutory requirement for a mandatory stay. Salford Estates has, as a binding decision of the Court of Appeal, generally been followed in England, although not always with much enthusiasm. It has also been followed in Malaysia and Singapore, but there have been divergent decisions in Hong Kong. By contrast, the courts of the British Virgin Islands have taken the opposite view, both at first instance and in the Court of Appeal. A similar question relating to the boundary between liquidation and exclusive jurisdiction clauses has led to even more widely divergent decisions, both in England and elsewhere. Academic opinion around the common law world remains divided, although most commentators suggest that the extent to which arbitration and exclusive jurisdiction clauses ought to impinge upon a liquidation application should be governed by reference to the same principles. The board has decided that Salford Estates was wrongly decided for the following reasons. First, there was no reason given by the Court of Appeal why the policy favouring arbitration over court proceedings was wider than as delimited by the statutory provisions which require a mandatory stay of actions or claims, both in the British Virgin Islands and in England, and for that matter in the other common law jurisdictions to which I have referred. In each case, the legislature chose to define the exclusive boundary in which arbitration is to take precedence over proceedings in court by a formula which clearly does not extend to liquidation applications by creditors. Secondly, liquidation applications do not resolve anything about the existence, enforceability, or even amount of the relevant debt. They do not even enforce payment of the debt in the way that a court judgment does. The creditor still has to prove his debt in the liquidation process, and the liquidator is free to challenge the debt both as to liability and amount. There is thus no breach of the obligation in an arbitration clause not to have the matter resolved by a court, because the hearing of a liquidation application or the making of a liquidation order resolve nothing about the alleged debt. Thirdly, there is nothing contrary to the general objectives of arbitration, that is, efficiency, party autonomy, keeping people to their bargains, and non-interference by the courts, that a company should be put into liquidation on the basis of a debt which it does not genuinely dispute on substantial grounds. Fourthly, a conclusion that an arbitration clause does not inhibit liquidation on the basis of a debt which is not genuinely disputed on substantial grounds will encourage rather than dissuade parties from agreeing to arbitrate their disputes. A creditor party is more likely to agree to the inclusion of an arbitration clause if the result is not to require an arbitration award as the precondition for seeking to put the debtor party into liquidation where there is no genuine dispute about the debt. A conclusion that Salford Estates was wrongly decided, made on an appeal from the British Virgin Islands, would not automatically mean that it would cease to be binding in England. But in 2016, a 9-justice panel of the Supreme Court decided in a case called Willers and Joyce that the Judicial Committee of the Privy Council could, in an appropriate case, make a direction that its decision should be binding in the UK, notwithstanding an earlier decision of the Court of Appeal to the contrary. For the reasons given in the Board's judgment, we have concluded that such a direction should be given, so that the English courts should now no longer follow Salford Estates. This is the first occasion upon which the Board has done so. Finally, we have concluded, after hearing argument, that this was not a case in which an appeal lay to the Judicial Committee as of right. Nonetheless, we readily granted leave to appeal because of the wide public importance of the issue of law to be decided. The Board will therefore humbly advise His Majesty that this appeal should be dismissed. Court is now adjourned.